Good afternoon, everyone. My name is Wanda Wiegers. I'm chair of the Speakers Committee this term, and I'd like to welcome you to this, the fifth lecture in our Fall Speakers Series. First, I'd like to acknowledge that we are on Treaty 6 territory in the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I'd also like to acknowledge the contributions of the contributions of the McKercher Law Firm of Saskatchewan to the funding of the General Speakers Series. The lecture today is devoted to the subject of human rights and given by the holder of the Ariel F. Sallows Chair of Human Rights. This chair was established in January 1979 when the late Ariel F. Sallows QC of North Battleford, Saskatchewan, signed a trust agreement ensuring that the chair would be funded from his estate upon his death. The chair was the first endowed chair of human rights in any law school in Canada, and the endowment has since the late 1980s supported courses and research in human rights at the college at both undergraduate and graduate levels. Since January 1st of this year, Paul Finkelman has occupied the chair. He is a specialist in American legal history, U.S. constitutional law, race relations and the law, and an expert on the law of slavery, religious liberty, African American history, the American Civil War, and legal issues, as an aside, surrounding American sports. Paul received a BA in history from Syracuse University and his MA and PhD from the University of Chicago. He has held positions and taught in many law schools across the United States, including the University of Texas, Harvard Law School as a fellow in law and humanities, the Brooklyn Law School, the University of Tulsa, and the Albany Law School, where he was the President William McKinley Distinguished Professor of Law and Public Policy between 2006 and 2014, and where he is still a Professor Emeritus. Paul has been an incredibly prolific scholar. He's the author or co-author, editor of over 40 books and more than 200 scholarly articles, as well as numerous book chapters, essays, book reviews, and guest lectures. He has written extensively on Thomas Jefferson and Abraham Lincoln. His work on legal history and constitutional law has been cited by the U.S. Supreme Court in numerous other courts and in many appellate briefs. His op-eds and shorter pieces have appeared in the New York Times, the Washington Post, USA Today, and on Huffington Post. Paul has been a great contributor to the life of the college over the past year. His topic today is Unjust Justices, the U.S. Supreme Court, the Problem of Slavery, and Modern Human Rights. Please join me in welcoming him.
Thank you very much. Can you hear me in the back? Thank you, Wanda. It's, of course, a delight to be here, and it is an honor to hold the Sallows Chair. It is an internationally known chair for human rights, and I think it is simply wonderful that a graduate of the law school would turn his estate over to such a worthy cause, and I'm truly honored to be the recipient of the chair and the holder of the chair. What I would like to talk about today is the problem of human rights and slavery and the American Supreme Court. And this comes out of a book that I am currently writing. So much of what you will hear today is new. I have not shared it with audiences before, and some of it, quite frankly, was startling to me. What I want to suggest in this lecture is that understanding legal history and understanding the history and even the biographies of key players in the development of law is critical to understanding the way law has developed, and also critical to understanding human rights. And what I want to focus on today is one American Supreme Court Justice, Chief Justice John Marshall. If there is anyone probably outside of the current Supreme Court that a Canadian lawyer or law professor or law student might have heard of from the U.S. Supreme Court, it would be Chief Justice Marshall. He is known as the Great Chief Justice. He is appointed to the court in 1801. He dies in 1835, making him the longest-serving Chief Justice in U.S. history. And he comes to the court at a particularly crucial moment because at the time the U.S. Supreme Court is not a co-equal third branch of the government the way the Americans talk about it today. Today we talk about the executive branch, the presidency, the legislature, Congress, and the judiciary, always embodied by the U.S. Supreme Court. But in 1800, the Supreme Court is not very important. It hears very few cases. It has decided not very much. And one of its earliest cases is promptly overturned by a constitutional amendment because the nation is so appalled by what the court says in a particular case, involving, of course, the stuff which makes lawyers lawyers, but which most other people don't want to think about, which is jurisdiction, who has standing to sue in a case. And so that's the record of the Supreme Court when Marshall goes on the court. Marshall is put on the court by John Adams, who is, of course, one of the great American founders, a co-author of the Declaration of Independence, the second president of the United States. But Marshall is put on the court after Adams has been defeated for re-election. Some of you may be watching one of the many circuses that are happening south of the border these days. And one of the sort of sideshow of the main circus, the sideshow is the decision by the Republicans who dominate the U.S. Senate not to even consider President Obama's last nomination to the Supreme Court on the grounds that, in fact, they should not consider a Supreme Court nominee because it's an election year. I did a short piece in the Huffington Post pointing out that about 20 Supreme Court justices have been put on the court during an election year. The most recent being Justice Anthony Kennedy, who was nominated by Reagan and who was confirmed by a Democratic Senate, even though Reagan was a Republican, during the election year of 1988, when many people assumed that the Republicans would lose the election, and therefore had Democrats played the kind of game that the current Republicans in the Senate are playing, they would have said, we're not letting you have an appointment in an election year, especially since we think we're going to win and we want to keep it open for us. But this has never been done until today. So again, when you watch the sideshow of the main circus, you can appreciate that this sideshow is unique. And the contrast with Marshall is astounding because Marshall is put on the court after Adams has actually been defeated for re-election. But in those days, there was a long period of time from the November election until March 4th when the new president took office. And so in January, Marshall is nominated for the court, confirmed by the Senate. He gets his commission. He has all the paperwork in order. And he remains Secretary of State of the United States until March 3rd, 1801, the day before he's going to leave office as Secretary of State. And that's when he puts on his Chief Justice hat and serves as Chief Justice. So this is the fame of Marshall coming in. He serves for a very long time. He hears many, many important cases, and much of American constitutional law is still based on Marshall decisions. In fact, of the 10 most cited Supreme Court decisions in American history, 5 of them are Marshall Court opinions. 4 of them written by Marshall, 1 written by someone else because Marshall recused himself in that case, although many of us suspect that he actually ghost wrote the opinion. Very powerful, very important. Contract law, interstate commerce law, international law, all come out of the Marshall Court. And he has famous intellectual duels with Thomas Jefferson, who despises Marshall. Marshall and Jefferson, of course, are cousins because among the very elite, wealthy planters of Virginia, everybody's a cousin to somebody else. They're distant cousins. He hates his cousin, Marshall, and in fact, he tells people you should never get into an argument with Justice Marshall because if you agree that the sun rises in the east, the next thing you'll agree to is some major public policy decision, because Marshall will lead you down the path. He, in a sense, invented the Socratic method in a way that all of us pathetic law professors have been trying to emulate ever since. But I don't want to talk about his greatness. I want to talk about slavery, because it's important to understand that John Marshall is also the Chief Justice of a slaveholders' republic. I am in the process of writing a book called Unjust Justices. Harvard University Press will publish it later next year, assuming that I actually get it finished and sent to them before my editor takes out a contract on me for not having the book in on time. And I will look at how three important Supreme Court justices in the 19th century dealt with slavery: Chief Justice Marshall, Justice Joseph Story, and Chief Justice Roger B. Taney. Now, when I started this project, as people do, by reading a biography or two. So I read the biographies of John Marshall, and every biography of John Marshall said the same thing. They said he lived in a very nice house in Richmond. He owned a dozen or so house slaves. It's a kind of a vague term, a dozen or so. Is it a baker's dozen? Is it almost a dozen? A dozen or so, and the biographers always said house servants. They didn't actually call them slaves. So he owned house servants, a dozen or so, and that he heard very, very few cases on slavery, and at most his biographers would talk about two of them. One was a lawsuit brought in the District of Columbia by a slave who claimed to be free because the slave claimed that her mother had never been a slave, and under American slave law, you followed the status of your mother, so if your mother had been free, then you can't be a slave. And the other, a very convoluted case involving the illegal African slave trade, in which the court has to decide which group of slaves in a illegal trader get sent into slavery and which go free, because some of them were illegally owned by Americans and therefore they get to be free, but some of them were legally owned perhaps by Spanish slave traders, and since the slave trade was legal into Cuba, they would be legal slaves. So you see this court struggling over how to determine the fate of human beings. So that's one story, and that's the story I went with. I didn't like Marshall's opinion in the Antelope case, which is the case dealing with the African slave trade, and I was fully prepared to eviscerate it to the best of my ability. And so I started reading about John Marshall's life. And I read his will. And what struck me interestingly about his will is that he wrote the will 3 times, which I guess happens when you get to be really old. Fortunately, Ariel Sallows only wrote his will once and then didn't get to rewrite it, so I'm here. But Marshall writes his will 3 times. First time is around 1827. And in his 1827 will, Marshall says, "I leave my slaves in Richmond," and he proceeds to name them, "to my wife." Well, that's pretty normal thing. And after she dies, they will go to my daughter. So his wife doesn't get actual ownership. She gets a life estate in the slaves. And of course, those of you who've studied property understand what a life estate is. But it's a little weirder when you're talking about a life estate in a human being. And when one thinks about the great Chief Justice John Marshall, and you think about the justice part of this, you ask yourself the question, where is the justice in giving somebody a life estate in another human being and then having that other human being pass on to somebody else as a permanent form of property? And so he lists his slaves. Well, it turns out that, in fact, in 1827, Marshall lists 15 slaves, not a dozen. I guess 15 is kind of a dozen or so. And then he adds, "and the children of my slave Jane." So it's 15 plus however many children Jane might have, and he doesn't even bother to tell us. So at one level, we have the idea that these are human beings in his household. These are the people who make his breakfast and wash his clothes and start the fire in the morning when it's a cold, snowy morning and take care of his horse and wait on him and bring him coffee or tea when he's writing an opinion and bring him wine at night to calm down from having worked all day writing opinions. And he can't even be bothered to tell us the names of the children of one of his slaves. So now we're up to like 16, 17, maybe 18 slaves. Well, all right, 18 slaves, that's kind of a dozen or so, maybe a dozen and a half. You know, who's counting, right? When you negotiate for salary, you know, your boss will say, I'll give you a dozen or so pictures of the Queen, and you'll say, no, I want, you know, a dozen and a half. Right? I think that's the equivalent of pictures of Ben Franklin in the U.S., right? The $100 bill. So that's that. And then I read the next paragraph of the will. Now, keep in mind, every biographer has read these wills. I'm not the first person to do this. And the next paragraph says, I give to my nephew my plantation at Chickahominy, which is actually today suburban Richmond, Virginia. My plantation at Chickahominy with all the slaves on it to hold in trust with the income to go to my wife and then to my daughter. I'm scratching my head. Every biographer has said he owns a dozen slaves. By the way, what's a dozen slaves worth? In today's market, maybe $1 million. Dozen slaves is a lot of people. It's a lot of slaves. He must have a really nice big house to have that many people scurrying around all day long doing things for him. And I'm thinking, wait a minute now, how many are at Chickahominy? And then I read the next paragraph, and he says, I give to my son Edward all the land he is living on in Fauquier County, which is way out west, with the usual number of slaves on it. And I'm thinking, well, what are the usual number of slaves? This is all very vague and weird. And then the next paragraph, I give to my son John Jr. the land he's living on in Fauquier County and all the slaves on it. And I'm thinking, there's a lot more than a dozen people here, even more than the 18 maybe in his house. And so I do what a historian should do. And by the way, what many very good historians, some of whom are my friends, I hope they'll remain my friends after I publish this, who have written about Marshall, have not done, which is I go to the U.S. Census. And lo and behold, I discover that there is a large chunk of land owned by J. Marshall, listed as a lawyer-judge profession in Chickahominy, and it has 62 slaves on it. Well, this is a lot more than a dozen. Even with my pathetic math skills, I know, if I were really good in math, I might not be a law professor. But 62 is a lot more than, and then I recounted and included there's actually 65, because it's hard to count all this. So I've got 65 slaves in Chickahominy. I still don't know how many are out in the county, out west. Then I get the 1830 will, rewrote it. 1830 will is basically the same will, except now for his son Edward, he says, I give my son Edward the land he resides on, the slaves having already been conveyed. That is, he's already given him the slaves. So I can scurry off to the 1830 census and discover that Edward Marshall, age 25, basically the age of many of you people, is the proud owner of 27 slaves. 27 slaves would today be a couple of $1 million. I'm pretty sure that 25-year-old Edward didn't acquire these slaves on his own. Rather, by the way, because he's 25, he doesn't show up in the previous census because he's only 15 then. Rather, these are the slaves that Daddy has already given him. John Jr., who's older, still hasn't gotten his slaves, and then John Jr. dies, predeceasing John Marshall. And John Marshall writes to one of his other sons. He has many sons. And he says, John died, leaving lots of debts. John was Marshall's great disappointment. He was clearly an alcoholic. He was a spendthrift. He's constantly in debt or teetering on bankruptcy. Daddy's always having to bail him out. And now John Jr. is dead. He's, of course, left Chief Justice Marshall with grandchildren and a daughter-in-law who's now the widow, and granddaddy, father-in-law, Chief Justice has to take care of the family. So he tells his son to sell all the slaves that John Jr. had on his plantation to pay the debts, have an auction off the slaves. Now John Marshall's a very wealthy man. He owns stock in banks. He is beginning to buy stock in this new strange piece of technology called the railroad. He's beginning to own railroad stocks. He owns stock in canals, which are very important. He owns lots of bonds. He has bank accounts. This is a very, very wealthy man. He also owns approximately, give or take a small town or two, 200,000 acres of land scattered around Virginia. This is a man who has invested wisely. By the way, he inherited none of this. He acquired this by simply buying, knowing when to buy, and sinking his money into investments. It's important to understand that he has all these investments because he could easily have sold a couple of bonds, sold a little stock, taken some money out of the bank, and paid off his son's debts. But rather than dip into the household cash, he instead prefers to have a significant number of people sold at auction. Now, when you sell a slave at auction, the slave is bought by whoever has the highest bid. And when you sell slaves at auction, you don't sell a family. You don't sell mommy and daddy and the three kids as a group. You sell daddy, you sell mommy, you sell the three kids one at a time. If the kids are very young, if they're under 5 or 6, they will be sold with the mother. But if they're 7 or 8 or anything above that, they're sold separately because they're valuable property on their own. So families are going to be spread all over Virginia as these slaves are bought. When one thinks about human rights, you realize that the most fundamental human rights that any of us seek after we get something to eat is to have a relationship with our families, to have loved ones that we can build families with, that we can build relationships with. And when you think of the horrors of American slavery, or you think of the horrors of people escaping war-torn Syria in however they can, you realize that what we are watching in Syria, just as we watched with American slavery, and I should add, by the way, there was, of course, slavery in Canada, Upper Canada, as it was called then, later Ontario, begins to end slavery in 1793. That's very early on. French-speaking Quebec takes a little while longer. So that slavery continues in Canada in some parts until the British Empire ends slavery in 1833. And of course, there is slavery all over the British Caribbean. And historically, the largest slave traders in the Western world have been the British. There's even a larger slave trade, what's known as the Indian Ocean slave trade of the Islamic slave trade of Muslims moving black Africans into what is today the Indian subcontinent. That's even a bigger slave trade than the Atlantic slave trade, but we don't talk about that much, perhaps because it's so far away from us and not as immediately connected to our own world. But in any event, so slavery, there's a lot of guilt, in other words, to be spread around here. It's not just the U.S., it's the British, it's the Canadians, it's the Jamaicans, it's everybody. But when you auction off your slaves in Virginia, you are dividing families, you are separating families. A wonderful example of the callousness of the the ability of a human being to simply ignore the most fundamental human rights of other people is Marshall's cousin, Thomas Jefferson. In Thomas Jefferson's will, he provides that his blacksmith, who is a very skilled blacksmith, should become free under the will. It's one of the 5 people he frees in the will. It's a brother of his mistress, Sally Hemings. And he doesn't, by the way, bother to free Sally. I think he's forgot about her. But in any event, he says that his blacksmith, Joe Fawcett, should go free. And Joe Fawcett should be allowed to live in his cabin at Monticello for the rest of his life. And Joe Fawcett will be given, and therefore own, all of his blacksmith tools. This is a really good thing for Joe Fawcett. And furthermore, that Joe Fawcett could live in his cabin on Monticello with his wife and children. Really nice, except for one thing. Jefferson doesn't emancipate the wife and children. So that the day that Joe Fawcett gets free, he sees his wife and 8 children sold off to about 5 or 6 different purchasers around the state of Virginia. And Joe Fawcett spends the rest of his life trying to buy back his family before he dies. He ultimately is able to purchase his wife and free her, purchase a couple of his kids, but not all of them. So this is the nature of John Marshall when he says, to pay my son's debts, to pay for my son's personal failures, to manage his money and to stay sober, we will turn to the slaves, which I have owned all these years and lent to my son, and they will be sold off. We don't know how many slaves were sold at that auction. I'm trying to see if I can find some newspaper record, because there's probably an advertisement, 50 slaves being sold, 30 slaves, whatever. I might be able to find that. It's very hard to dig this stuff out because it is so obscure. And then, after saying we'll sell the slaves, Marshall says, we should also sell those slaves which my son's widow wants to keep as family servants. But when they're up for auction, I want you to buy them in my name. So Marshall is actually buying the slaves from himself at the auction, and those servants go back to his daughter-in-law. We don't know how many there are. But I did find the daughter-in-law in the 1840 census, and she owns about 40 slaves. So we're talking about huge numbers of people, huge numbers of slaves. Or as an American politician might say, huge numbers of slaves. And in addition to this, we discover that Marshall owns a whole bunch of land in Farquhar County in his own name. And there are slaves on those. I currently have John Marshall owning about 150 or 60 slaves in 1830, which is 5 years before his death. Now, what's fascinating is John Marshall inherited about 4 or 5 slaves from his father. When he got married, his father gave him a slave as a wedding present. That's a very common wedding present in Virginia if you're wealthy enough. Couples getting married, they have to have somebody to do the dishes. So here, have a slave. So he gets 4 or 5 slaves, maybe 6 at most. Where did these other 130 or 40 or 50 slaves come from? Obviously, they've come from the fact that throughout his life, the Chief Justice of the United States is buying and selling human flesh in fairly large quantities. Marshall's papers are sometimes very full and helpful, sometimes scattered. It's clear he burned many of his personal papers. Many of his financial records were burned. But we do have his financial notebooks from the 1780s and 1790s. And if you go through these notebooks, you see that every few months he says, I bought a Negro girl here. I bought a Negro man here. I bought Joe here. Sometimes these people have names, actually, and many times they don't have names because they are commodities. It's kind of like, I bought a car last week. And then in my diary, I bought a Subaru. So sometimes my cars have names and sometimes they don't. And that's how John Marshall is with his slaves. But we see him buying slaves. In November 1786, he pays 50 pounds for 2 slaves. And in April 1787, he buys a slave named Israel for 55 pounds. In May of that year, he also pays 55 pounds for a woman bought in Gloucester. Apparently, she's a nameless woman. And so it goes. So we see the way he operates, but we only have it for a couple of years. Now, here's what astounds me about all this. This is a man who's had many biographies written about him. Many very good scholars have written biographies. There are printed papers, published papers, the papers of John Marshall, put together very, very carefully by a very careful and smart and wonderful group of scholars who collected literally every paper that John Marshall ever touched and printed it and annotated it. That's where the 3 wills are set out. And yet none of these people, in transcribing these wills, noticed the slaves at Chickahominy, the slaves that my son Edward had, the slaves that my son James has, my son John Jr. has. None of them seems to have noticed any of this. And so they all write, he owned a dozen or so slaves. When I found this research, I was just blown away. And this, I suppose, is in part the joy of being a scholar, that you find something that you figure there can't be anything new to say. And you scratch around a little, and suddenly out pops gigantic new things to say because you are looking in ways that other people have not looked. So I typed up a couple of paragraphs about this, and I sent it to 2 people. One was the editor of the John Marshall papers, a very good scholar, somebody who I admire and like, a guy named Chuck Hobson, who's at the College of William and Mary Law School. And I said, Chuck, I found this. What do you think? Because I want to, I kind of want him to say, well, oh no, that's not John Marshall in Chickahominy. That's Jerry Marshall. You got the wrong guy. I'm kind of thinking, you're going to. So I say he's got 65 slaves at Chickahominy. So he sent me back an email. He says, I was so interested in what you did that I immediately went on Ancestry.com to see for myself, i.e. he did not trust me. And so he wanted to do his own. And he said, you actually counted the slaves at Chickahominy wrong. There aren't 65, there are only 62. You added the overseer and his wife and his child, and that's how you got to 65. Oh, God, I've made just a horrendous quantitative error. The guys who went from a dozen to 18, a dozen becomes 18. That's not an error. That's only a 50% error. But my God, I had a 2% error. I'm sorry, a 5% error. I'm not good at math. I had a 5% error. This is a crisis from 62 to 65. I actually think there's 65. I think he miscounted. It's 65 plus the other 3. But who's going to argue, right? The other one is a very old friend of mine who I've known for a very long time, a guy named Kent Neumeyer, who's written a very, very good biography of Marshall. And I sent this to him, and he very graciously sent me a very quick email back saying, I wish I had done the research you did. And my thought, which of course I would never ask him about, is, why didn't you? You read the same will I read. It's staring at you. It's jumping out at you. No, so my answer is the reason you didn't do the research is because you didn't want to do the research. Because if you did the research, you would come to the startling conclusion that by the way, his book is John Marshall and the Heroic Age of the Supreme Court. And the problem is the hero of the heroic age might be a little bit less heroic if you see him as somebody who buys and sells human beings his whole life. And if I were talking about Jefferson, which I have written about, in fact, for many years I was sort of blackballed from conferences at Monticello or the University of Virginia because they didn't like what I said, even though now they agree I'm right. But you know that happens. If I'd written about Jefferson, the Jefferson defenders, of which there are many, would have said, well, you know, it's not his fault he inherited all these slaves. He didn't know what to do with them. Except for Sally. He didn't know what to do. Well, but they wouldn't admit that. I'm sorry. I've got Trumpitis. I'm really sorry. But in any event, his defenders would say he inherited these slaves and he didn't know what to do with them, so he kept them. But with John Marshall, you can't even say that because he didn't inherit them. He bought them. And then he sold them, and he bought more, and he bought more, and then he gave them away to his children. So that's one piece of Marshall. And I think if you look at his jurisprudence, you have to ask the question, how is it that owning more than 130 slaves, how is it that that affects your jurisprudence? What does this say about who you are as a judge? And so now I want to turn to another set of cases, because John Marshall, as Chief Justice of the U.S. Supreme Court, has relatively limited jurisdiction. He can only hear cases involving the Constitution or federal law where there is a reason for it to get to the Supreme Court. Often these are what are called in the U.S. diversity cases, a suit between one citizen of one state and a citizen of another state. However, because the District of Columbia is not a state, it's the national capital, under the laws of the United States, the District of Columbia has no Supreme Court of its own. And if you have a case in the District of Columbia in the 19th century, the ultimate appeal is to the U.S. Supreme Court. So John Marshall, as Chief Justice, hears a fair number of cases that are run-of-the-mill, average, everyday legal cases coming out of the District of Columbia. They're not big constitutional issues. And most of Marshall's biographers simply ignore these cases, because they're not about how you interpret the Commerce Clause. They're not about how you deal with separation of powers. They're not about the executive versus the legislature. They're just run-of-the-mill cases. But when you look at these run-of-the-mill cases, what you see is that a significant number of them involve slaves. There are 14 cases that come before Marshall. Its average is almost one every 2 years, involving slaves who have a claim to be free. In 1806, Marshall heard the case of Scott versus Negro London. Negro London, as he's called, claims to be free because he was illegally imported into Virginia. Although Virginia is a slave state, it does not allow the importation of slaves for sale. If you move into Virginia, you can bring your slaves with you, but you can't go to South Carolina and buy a bunch of slaves and bring them into Virginia. And a slave trader can't come into Virginia and sell you slaves. The idea is that Virginia doesn't want all this outflow of capital. It's a simple economic regulation, perhaps compounded by sort of police powers regulations. We don't want too many slaves coming into the state. Washington, D.C. is at the time two counties, Alexandria County and Washington County. Alexandria County came from Virginia. So the laws of Virginia actually apply to Washington, D.C., unless they've been changed by Congress. So Negro London, living in Alexandria County, which is part of Washington, D.C., sues for freedom on the grounds that he was not properly imported into Washington, D.C. under Virginia law, and therefore, having not been imported properly, he was free. Now, the case is fascinating because it's very clear that the person who imported London did not follow the rules required by Virginia law. One of them was that you had, if you were moving into the area, you had to register with a local official and register the slaves that you were bringing in. And you had a certain number of months to do this, and if you didn't do it, then your slaves went free. The facts seem to be in favor of London. But Marshall determines that it wouldn't be fair to apply these facts to this case because the law allows you to register your slave, requires you actually to register your slave with a naval officer from the United States Navy, and it would be wrong to allow a naval officer to determine whether somebody gets to keep his property or not. But of course, the naval officer isn't determining that. He's merely the administrative actor. He's merely like the court clerk. They don't have court clerks yet. They have to use whatever officials they can have. Had this been any other case but a slave case, one would have imagined the court would have said, yeah, the government has a right to say who is going to be able to register and who is not going to be able to register. So London loses, and a few years later, a guy named Ben loses under the same set of facts. A couple of years after that, we have the case of Hezekiah Wood versus John Davis and others. Now, John Davis is a slave, the son of a woman named Susan Davis. Susan Davis lives in Maryland. John Davis has been bought and moved to Washington County, which used to be part of Maryland and is therefore under Maryland law. Susan Davis sues for her freedom in Maryland, claiming that her mother was never a slave, and therefore she's not a slave. And a jury of 12 white men in Maryland say, yes, your mother was never a slave, you go free. And Susan Davis, therefore, is a free woman. John Davis goes into a court in the District of Columbia and says, well, if my mother was never a slave, Susan, and here's the court record, then I can't possibly be a slave. And the court agrees, and a jury of 12 white men in Washington, D.C. says, John Davis, you get to go free. Mr. Woods, who owns Davis, appeals to the U.S. Supreme Court, and John Marshall comes up with the weird decision that Mr. Woods was not a party to the lawsuit in Maryland determining whether Susan Davis was free, and therefore that ruling does not apply to Mr. Woods, and therefore John is not free. John then sues again and tries to, in other words, to get a Washington, D.C. jury to look at the same evidence that the Maryland court looked at. The D.C. jury looks at it, and it gets back to Marshall, and Marshall again finds another reason for not allowing him to be free. All of these cases are astounding in their analytical approach because they don't fit into anything that would imply that John Marshall is the great Chief Justice. In the Davis case, Marshall says that the Susan Davis's decision making her free, quote, was not conclusive evidence in the present case because there was no privity between Wood and the man who owned Susan Davis. But of course, every slave state at this time would have accepted the evidence of Susan Davis as proving that her son was free. And in fact, there are almost identical cases in both Virginia and Maryland where those state courts say, you're free because we proved that your mother was free, but not the great Chief Justice. The one case that his biographers sometimes known is a case called Mima Queen versus Hepburn. Mima Queen is a slave, again, originally from Maryland, in the Maryland section of the District of Columbia. Mima Queen is represented by none other than Francis Scott Key, who will later be the author of the Star-Spangled Banner, the American national anthem. Francis Scott Key is also the former law partner of a rising young lawyer in Maryland named Roger Brooke Tawney, who will succeed John Marshall as Chief Justice of the United States. And the Keys are an extremely important political family in both Washington, D.C. and Maryland. Francis Scott Key will ultimately be the district attorney in Washington, D.C. Key argues that Mima Queen should be allowed to use hearsay evidence to prove that her mother was free because the Maryland courts always allow hearsay evidence in freedom suits because, as the Maryland courts note, slaves can't read. They don't have any documentary proof. And furthermore, Key points out that in real estate cases, in boundary cases, in real property cases, hearsay evidence is always allowed going all the way back to medieval England. Why do you allow hearsay cases in a boundary dispute? Because the deed says you own all the land from the river to the big oak tree. Well, the big oak tree has become firewood. And so how do you prove where the big oak tree was? You prove it by hearsay evidence because nobody has a photograph of where the big oak tree, photography hasn't been invented. So you have to allow hearsay evidence. And what Chief Justice Marshall says in this case is that if we allowed this kind of evidence, it would threaten all property in America. All of the property owners in America would be threatened if you allow hearsay evidence in the single case of Mima Queen. At this time, there are rarely dissents in the Supreme Court. It's not considered polite to disagree with John and whatever he writes. In this case, there is an elaborate defense from a man who had been on the Maryland Court of Appeals, the highest court in Maryland, before he went to the U.S. Supreme Court. He is the expert on Maryland law, a man named Gabriel Duval. And Justice Duval writes a stinging dissent, chastising Marshall for ignoring Maryland precedent, saying that this is from the Maryland part of Washington, D.C. You have to apply Maryland law, and you're not doing it. And the reason scholars mention this case is because of the Duval dissent. It sort of jumps out and they can't hide. And so they mention it. I could go on, but we have limited amounts of time, and I want to leave a little bit for question. I will simply say this, that what I discovered is that there are 14 cases involving freedom suits that the Marshall Court hears. John Marshall decides 7 of them, and the slaves lose in every single one of these 7 cases. There is one more case decided by Justice Johnson, who's put on the court by Thomas Jefferson, and the slaves lose there. That's 8 cases. In the remaining 5 cases, all decided by judges appointed by James Monroe and Andrew Jackson, the slaves win. Marshall doesn't dissent in any of these cases because dissenting isn't done very often. But what's clear to me after looking at the whole picture is that he doesn't write the opinions in these cases because he can't get the court to accept his narrow, constricted view of human beings as property in all of these freedom cases. John Marshall never finds an argument that would free a slave. And maybe the reason for that is because in the back of his mind, He is always concerned about the 150 or so that he owns. And he's always wondering, maybe I bought a slave whose mother turned out to be free, and therefore I'm going to have to give up a little bit of my property so this person can live a life as a free person. So this is the sad tale of the great American Chief Justice, and I think it tells us something about the nature of law in our world. And our world is both Canada and the United States and Great Britain and all of the common law countries, because we all share a legal heritage. And it's worth knowing not only where your justices went to law school and how smart they were and how much they know, but perhaps it's worth knowing something about what they did in their lives besides practicing law, or what kind of law they practice. One of the great problems with the current U.S. Supreme Court is that, with the exception of Justice Ginsburg, or as she's known, the notorious RBG, Ruth Bader Ginsburg, and you can get T-shirts that have her picture. It's amazing to have this woman justice in her 80s who's become a pop culture figure with T-shirts for her. With the exception of Justice Ginsburg, there is nobody on the U.S. Supreme Court today who has ever practiced public interest law, who has ever worked for real flesh and blood clients. They are all people who went from law school to perhaps a judicial clerkship, in the case of Chief Justice Roberts, to a Supreme Court clerkship, and then on to Wall Street, and then on to the higher, and sometimes onto the higher levels of government service where they work in the Attorney General's office. And none of them have dealt with real flesh and blood clients. None of them, except Ginsburg, have worked for poor people. None of them have worked for real people. And by the way, I say this about the justices who I like on the court as well as those who I don't like. I think it doesn't matter. They do not have anything that would resemble a human connection to the law. And I think when you think about human rights law, and you think about how do you become an advocate for human rights, even if that is not your practice, even if you are doing commercial law, even if you are doing insurance litigation, whatever you're doing, you're always going to have a human rights connection to something that you do. And the important thing to understand is that before you can understand human rights, you have to at least occasionally have interacted with a human being in your law practice. And I will leave it with that. Thank you.